We've been talking about default, dismissal, and summary judgment, ways that parties push each other out of lawsuits or sometimes push themselves out of lawsuits. Let's start with default. Default is when the defendant fails to participate in some way. And when the defendant does that, we treat that as admitting liability. So just like when an answer fails to address an allegation in a complaint, we treat that as admitting that allegation. If the defendant fails to defend, we treat that as admitting liability. There's a couple of ways that this can happen. If the defendant fails to appear or defend at all, then the clerk of the court has to enter default, and they can find out about that by the plaintiff basically giving them evidence of failure to appear or defend. Now, appearance is something that we don't talk about that much in this class because it's basically a formality, but it is the first thing that the defendant does to make themselves known to the court, is put in an appearance saying, I'm the lawyer who's acting in this matter, or I'm representing myself pro se. So it's kind of like introducing yourself to the court is appearing. And if you fail to do that, or do that and then fail to defend by, say, responding to a complaint, then the defendant will be in default. Another way to get kicked out of court is to fail to obey a court order, such as a discovery order. It's not necessarily the sanction for that, but one option that the court has is to enter default. So note that default just means that the person has lost the case and has been adjudged liable by default. It doesn't mean that they yet have to pay any money or do anything. That is the default judgment under Rule 55B. After the default has been entered in the way described before, the default judgment can be entered then. And the way it works is if we know how much it's for, if there's clear evidence, say there's liquidated damages in a contract or a debt, then the clerk can simply enter that as the judgment. If it's more complicated, then you have to apply to the court to ask it to evaluate how much the defendant should owe. Now, as we discussed today with Peralta, courts in general, systemically, really do not like default judgment. And there are many, many reasons for rescinding default judgment. In Peralta, we saw a kind of constitutional reason where the court said that the requirements of notice overcome the propriety of default judgment, and so since there wasn't proper notice, default judgment was improper, even though the defendant would most likely have lost on the merits anyway. But aside from those sorts of situations, there's lots and lots of reasons why a court might revoke default judgment under Rule 60, including a mistake or an excuse, so some sort of understandable situation that's maybe beyond the defendant's control, newly discovered evidence, various misbehavior on the part of the plaintiff. And all those have to be entered, the defendant has to request reinstatement of the lawsuit and rescission of the default within a year of the judgment. But at any reasonable time, so again, when you see reasonable, you know it's highly discretionary, the court can rescind default judgment if it seems like it's no longer equitable or for any other reason that justifies relief. So this is a really discretionary kind of policy judgment on the part of the court. Okay, so default is for kicking defendants out of the lawsuit. Dismissal is for kicking plaintiffs out of the lawsuit. And there's two kinds of dismissal because sometimes plaintiffs want to leave the lawsuit and sometimes they don't. Voluntary dismissal under Rule 41 allows plaintiff to drop the lawsuit all by themselves if the defendant has not yet responded, or with the defendant's agreement if the defendant has already responded. Now, if the defendant has already responded and does not agree to dropping the lawsuit, the plaintiff can still convince the court that that's the best course of action. If that happens, though, then the defendant's counterclaims stay alive. Crucially, if the plaintiff has dismissed the action twice already, they cannot sue again on the same claim, the two-shot rule, two-dismissal rule. So the idea there is that plaintiffs don't get to harass defendants by continually filing suits and then dropping them. So we limit how many times the person can file a claim. Relatedly, involuntary dismissal has a similar, also has a limit. Once something is involuntarily dismissed, you cannot refile it. You don't get another chance. And involuntary dismissal happens when the plaintiff fails to participate, so doesn't comply with discovery orders or the rules, or otherwise properly participate in the lawsuit. So default for defendants, dismissal for plaintiffs. Settlement ends litigation, sometimes before it starts, although often when it's already started. And what settlement does basically is create a contract between the parties wherein they agree to resolve the lawsuit in some way. So most typically, and pretty universally, you'll agree to dismiss the lawsuit under some agreed upon conditions. So here's a place where voluntary dismissal becomes really important, right? Here you have a situation where the plaintiff will have agreement from the defendant to dismiss the lawsuit, and they can just decide to do that because they have found conditions on which they are willing to forgo litigation. As a default, violations of a settlement provision are a violation of a contract because a settlement creates a contract between the parties. The settlement can include all sorts of conditions, as we talked about, including confidentiality, including no related future suits. In other words, the plaintiff can agree to release the defendant from liability for the claim they have made and any other claim that could potentially arise out of the situation or their relationship or whatever. As we've seen, some of these things can be overridden by a court order. So in Kalanauskas, we saw how the confidentiality agreement was to some extent overridden by the court order. The court order did not eliminate the confidentiality agreement altogether, but it basically weighed the matter and said it's in the public interest for the plaintiff in a previous lawsuit to be able to be disposed about their experiences at work in the current lawsuit, which deals with a similar kind of experience at work, right? So the point of the current litigation is to show a pattern or practice, condoning by management of inappropriate behavior and stuff like that. That is in the public interest to allow that litigation to go forward, but the plaintiff from the first suit can still be barred from talking about the settlement itself. One really key thing in terms of the attorney's obligations is to protect their client's interest in case the other party fails to fulfill the bargain. And a couple of ways of doing that are to file suit as a contract violation, of course. But an alternative is to ask the court to retain jurisdiction to help effectuate the conditions that the parties have agreed to. So the litigation stays live, even though it's held in abeyance. Still, a further alternative is to get a consent decree where the court effectively issues a judgment, but that judgment is the agreement of the parties. So then you have a legal statement, a legal judgment by the court, basically making the resolution of the case legally the thing that the parties have agreed to.